All right, thank you for staying with us. This morning, we get to talk about the rule of law in Nigeria, prosecution, jurisprudence, history, and of course, what it means for the public, enlightenment. It's no more news that the leader of the proscribed indigenous people of Biafra, Ipob, Nnamdi Kanu, has been sentenced to life imprisonment for, terrorism charge against the state. And it's been a long journey, almost a decade of trial for the man, Nnamdi Kanu. Justice James Omotosho of the Federal High Court sentenced Nnamdi Kanu, to life imprisonment after 10 years of trial. And Justice Omotosho delivered the judgment on Thursday, 4 years after Kanu was arrested in Kenya under contentious circumstances and brought back to Nigeria. And the judgment was delivered in Kanu's absence after the Ipob leader insisted that the judgment would not be delivered in terrorism charge. The federal government entered against him. And, there was a mild drama, actually, a lot of drama, not really mild, where there was an outburst from the man agitating, for that particular reason of the judgment not being delivered. And it's been 10 years of multiple episodes of drama, actually. It's been a long one. Omotosho stated, in fact, during that yesterday's drama, the judge had to order that the security agents bundle him out of the court for what he called unruly behavior. And Justice Omotosho stated that several broadcasts by Kanu through Radio Biafra constituted act of terrorism, adding that his rhetoric and intention were anchored on violence. And of course, he was convicted on other charges as well that has multiple years and that will run concurrently. You get to see the pronouncement of Milord very shortly. But what does this mean? 10 years of trial for the man. When he was first arrested, he was detained, the case was taken to court, and he was given a bail. After that, the man, fled the country after what he called, an attack on his home. The federal government went to court and said he jumped bail. That bail was secured, the bail was given to him on the honor of the Senate's majority leader, then a minority leader, Ina Baribe. But when he fled the country, even Senator Baribe had to say, you can't give somebody a bail and still attack his home. Nobody will wait for him to be killed. And he fled the country. Even after that, the agitation continued. Mainly it was from, that a Biafra state be created that will, cover some Nigerian states, and there should be secession, and is at will, to commandeer a group of people to say, we don't want to be a part of this nation called Nigeria. Give us, allow us go, be separated from Nigeria and create a state of our own, a country of our own, that will be called Biafra state. And of course, the president then was President Muhammadu Buhari, who said they being a Nigerian state, or that toga of one Nigeria, is indivisible. It cannot be entertained at all. And of course, the rest is history, as they say. Fled the country, and from there, the agitation continued. So many things were said, so many things was alleged that he said that were violent in nature. Part of it is what Justice Omotosho said, a crime against the Nigerian state. So, has been given a life sentence. Some, persons are already reacting. The same Senator Eyinaya Baribe has said this is something against the entire Southeast. We have with us a constitutional lawyer, a law lecturer, Dr. Misbau Lateef. He joins us virtually. Dr. Lateef, thank you for joining us.
Yeah, thank you, and good morning to you and to Nigerians, wherever they are watching your station from.
Right. Now, Lord Justice Omotosho has handed down that sentencing yesterday on so many charges, but the chief of it all is that life sentence pronouncement, which he found Nnamdi guilty of committing act of terrorism against the Federal Republic of Nigeria. But some will say, we know how this will end. It was preconceived ab initio. That was the language used by Senator Ayina Abaribe, that this was preconceived, and he now expanded as a preconceived judgment against the people of the Southeast. But let's start with the person in the eye of the storm, Nnamdi Kanu. 10 years, and dramatic 10 years of prosecution. How will you describe what ended yesterday, at least an era?
Well, thank you and good morning once again. What happened yesterday, it was a climax, or maybe sometimes even an anticlimax, if you like, depending on what side of the aisle you are speaking from. So what we saw yesterday for me was actually a prophecy, well foretold in a manner of speech. It was really anticipated. And I guess perhaps the only challenge was that it had taken so long to come. And like you have rightly captured this, it has taken 10 years, and it has been 10 years of drama, tense, political, and all of those are things. And I think because this has dragged for so long, it has also, unfortunately, help in distorting, the perspective around the trial. And the trial actually started as a crime against the state of Nigeria, or the people of Nigeria, as was captured on the charge. But over time, because of the theatrics and the drama that Kanu or the defense team themselves introduced to the trial, has since gained the coloration of what some people call tribal war. And what you even said earlier regarding Senator Abaribe saying this was something preconceived, I think the most disheartening aspect for me is that because of this because of the long coming of the conclusion, it has given some people, and I would say that opportunity quite mischievously to now frame the issue, along the tribal lens, which originally was not actually the case. Kanu was arrested, for committing crime according to laws of Nigeria, crime bordering on terrorism. And abundant evidence, was presented before the court, as Justice Omotosho, clearly articulated in his well-detailed judgment yesterday. So for me, really, nothing has come here as a surprise. It was well anticipated, and I think it's a well-served judgment. I think Kanu got his well-deserved desert, if you like, in this case. He called for it, and he has now been served with the consequences of the laws of Nigeria. And I think this is a good news for our criminal justice system going forward. And I must clarify again that it has taken this long is also perhaps unfortunate, that our criminal justice system, will allow an accused person or a defendant to hold down the system for this long. Look at what happened in Finland when his accomplice, Simon Ekpa, was convicted and sentenced within just 1 or 2 years, over or even less, terrorism charges that were not even as consequential as what Kanu was alleged of doing in Nigeria. So for me, if this had happened as soon as he was arrested in 2015, some of the ethnic or tribal coloration that we have today will probably not have arisen. But because it has taken so long, then many people probably have lost a memory of events, and now they frame the accused person, in the picture of a hero, which is quite the contrary. So, but like I said, for me, it is a well-served judgment, a well-reasoned judgment, and I think we should commend Justice Omotosho for maintaining calmness, even in the face of the brass, the cocky, and even violent, attitude of the defendant, who, was expected to actually be remorseful, given the gravity of the charges against him. But then all through the trial, just like my lord, Judge Somoto just said yesterday, all through the trial, the defendant did not show any remorse. He was arrogant, and it was quite a very bad spectacle to see an accused person, behave that way in a court of law. Not even in the liberal West, would an accused person be allowed to constitute himself to a nuisance like that in a public court? Not anywhere in the US or UK. They could have actually restrained him. They could have cuffed him. He could have been cuffed in the court. And this is not me being unduly harsh. This is me actually calling for, proper administration of our justice system, so that when we have accused persons who show this kind of tendencies, the security agency should, properly apply the law to restrain them and save our justice system, from this kind of, I would say, embarrassing spectacle as we saw Kanu behave yesterday. So, but then he called for this.
All right.
Justice has been served, and I think it was well served.
All right, Dr. Misbau, I'd like to ask you, having been, having followed the whole case and all of that, how does yesterday's life sentence, how does it square with the Supreme Court's decision of 2023 that ruled that his rendition was illegal, but that the trial could continue?
Well, you see, different justice system, they have different rules and procedure, and I will start this way.
Okay.
In America, for example, their law of evidence or their justice system is such that if you obtain a piece of evidence illegally, you will not be able to tender that evidence in court for anything. Say someone actually stole your phone. And you caught them on camera, not on your own camera. Let's say somebody recorded them. You now went to the person who recorded them. You stole the phone by which they were recorded, and you wanted to present that in court. The fact that you stole the evidence will invalidate your trial in court. I don't know if that makes sense. But the point is that in Nigeria, that is not our legal system. So what the Supreme Court simply said was that the illegality of his rendition notwithstanding, the fact that he was eventually brought before or within the jurisdiction of Nigeria cannot, I would say, exclude him from criminal prosecution. So there are two different things. It was rendered illegally, fine. But then, does that exculpate him of criminal liability? The Supreme Court said no. So for us in Nigeria, it does not matter how an accused person was brought into our territory. It does not matter how a piece of evidence was obtained. If you obtain a piece of evidence, I would say illegally, but then that piece of evidence is relevant to prove a case, the court will not disregard that piece of evidence because of the process by which you obtain it. So it's a question of process and then substance. It was rendered in a manner that was procedurally wrong, but then the substance is that he was charged, with crime in Nigeria, and somehow they brought him to Nigeria, and of course, by law of Nigeria, he has to face his sentence. So the Supreme Court judgment has not in any way invalidated the judgment of yesterday. As a matter of fact, the reason why he was eventually tried was because the Supreme Court said his trial should proceed, just as you rightly said earlier.
All right.
Okay, the judge invoked Section 266 of the ACJA to deliver the verdict without Kanu in the court. How do you see this setting a precedent for other future high-profile cases like this in the country?
Well, it's a standard practice all over the world. An accused person or a defendant does not have to be present in court, particularly where they show violence. Where they show propensity to violence or violence, as we saw yesterday, before our very eyes. So yes, the law allows that an accused person could be absent, they could be restrained if they, but then, like I said, it is a standard, practice all over the world. Here in the UK, in the US, we are accused. In fact, in the US, like I said earlier, it could have been cuffed. All the violence, attitude or disposition he has shown so far, in the US, it could have been cuffed. You could have seen him in handcuff in that court, and he could have been restrained leg and hand. The UK is less, disposed to that kind of treatment, I would say, but the US is particularly notorious for that. He could have been restrained, and in the UK too could have been restrained, maybe not with chains in his leg. So the court deciding in his absence was something orchestrated by him because he called for it, and the judge had no choice but to invoke that provisions of the law because the process cannot wait for him. Remember, this process had taken this long because he literally orchestrated the delay. It was before Justice Murtala Nyako. It was one trouble or the other. He continued to create delay. And that was what he was also trying to do yesterday. If he had succeeded yesterday in disturbing or disrupting the proceeding, what would have followed naturally was another adjournment. And he was doing all of this. It was all theater, deliberately, maybe to get political solution. But you see, the irony here is that you probably wanted a political solution by dragging the case, but then your disposition and demeanor do not indicate remorsefulness. So if somebody wanted a political solution, he could have been remorseful, so that those who would help him, at least will have something to point at that, okay, he appears to be remorseful. I think, but then, so this for me are the kind of contradictions that the accused person himself threw up, and the reason why what could have mitigated his case eventually became an albatross for him. He lost all the opportunity at mitigation. And I should commend the judge again for actually not giving him a death sentence.
All right,
which
Dr.
is the
Misbau.
requirement of. Okay.
Yeah, talking about two things for me, but where you stopped right now, talking about the death sentence. My Lord, spoke about that, and he said, because of mercy, he even read a portion of the Bible, Matthew 27 or so, that, talked about being merciful, and that maybe that particular sentence, death sentence is no more popular, but he hinted his judgment more on a biblical verse that talk about mercy, and it was on that ground that he gave him that life sentence. And he described Nnamdi Kanu's behavior, in very harsh adjective, talking about him being rude, him being violent, him being cocky, him being arrogant, and all of those things. And so many persons will say, Dr. Lateef, that maybe the Nigerian state persecuted Nnamdi Kanu instead of prosecuting him. And I give you my reasons. Now, when the case was started 10 years ago, he was sued to court, he got a bail. At that time that he got a bail, the operator Python Dance under President Buhari came to the southeast and his home was attacked. He had to run for his life. That was his explanation. And which the senator who stood shorty for him said, will somebody wait because he's on bail to be killed? He left the country. He was brought back in very controversial circumstance. And, the man in his usual persona can be very vocal and harsh. Sometimes when he talks, a judge had to even recuse himself on this matter. Then there was a time that, in fact, many times, the DSS, the Nigerian state, amended the charges against Nnamdi Kanu so many times, and it was looking to many of his supporters like, is this really prosecution or persecution? He got some judgment in his favor that were never acted upon by the Nigerian state. At a time, Nnamdi Kanu was being dragged. The correctional facility are saying it belongs to us. At the time, it was the DSS, and we got here. One would say it's only human for somebody who has been frustrated to act in that manner. And, in the twilight of this particular case that has ended yesterday, at least at this point, he has a right to appeal if he wants to. Don't you think the Nigerian state really frustrated Nnamdi Kanu's trial on this matter? More of a persecution than prosecution.
Well, as much as I respect people's opinion, to be different on this matter, and then as much as I also recognize that this is an issue that has degenerated into controversies and all of that. Well, my own sense of the whole thing is that this has been a fair trial. I do not see persecution here, and those who say so, from what they have said, I don't think those are actually enough element to suggest or to prove what they call persecution. I give the Operation Python, for example. Why did Operation Python happen? It happened because of the state of crisis in the southeast. The government had to step in. Remember, the Boko Haram that we have today in Nigeria and the terrorism and banditry, they started, I would say in a very small version. Now they have developed into a very serious crisis. So what the government tried to do that time is to nip in the bud the crisis that was developing in the east. So that they invaded his house or whatever is not a justification for him to jump bail to start with. He could have run into another, maybe safe custody or wherever. Now, the states will simply not fold their arms and allow criminality to continue simply because somebody was on bail. So he jumped bail. That's another crime on its own. Now, that the amended charges, different time or whatever it is, well, it's also consistent with the requirement of law. Each of those times that the charges were amended, he was given the opportunity to also respond to them, to plead one way or the other. So my own reading is that Kanu was given sufficient legal facilities and opportunity to defend himself. Unfortunately, he bungled all of that. Look at what happened yesterday. Now, the judge actually, awarded 5 years and I think 20 years on particular charges, which the court found, lesser compared to other charges. And that was a case where he did not enter any defense. Imagine if he had entered a defense according to law. Perhaps his own sentencing could have been maybe a couple of years than what we saw yesterday. So if he had not bungled the opportunity to defend himself, he sacked his lawyer. He changed lawyer repeatedly. All of this are within his right. I must clarify that. There is no law that says an accused person cannot sack his lawyer or cannot defend themselves. But you see, when people do that, they should also understand the risk, that go with doing that. And he cannot blame anyone, for the risk associated for the step he has decided to take. Now, on the issue of whether he was cocky, he was arrogant, judges are allowed to make or take notice of such things. But I'm happy, and I watched the proceeding, that my Lord, even after saying that, said, regardless of his cockiness, arrogance, and everything, the court would overlook that and still serve justice. So what the judge did there smartly is to remove all doubt as to the basis of his conviction. So the judge did not convict him because he was arrogant or because he was cocky or because he was violent. No, the court convicted him because evidence were adduced against him, which he never, unfortunately, defended. So for me, really, I do not agree with people who see persecution. I see a proper prosecution. I should commend also the prosecuting team led by the latest Sikh, Awumalo SAN, and I think they did a commendable job. And I think going forward, this should be a template for the Nigerian state, to prosecute people, who are in the kind of Kanu shoe. I mean, terrorism, banditry, and all of that.
All right, Dr. Misbau, yesterday's judgment now, it sparked protests in Abia and Imo. How do you see this reigniting, political, not political per se, but yes, or further unrests in the region? And then more so as Igbo leaders are also meeting with Tinubu today or, in the coming days. How do you see these, with the judgment, the protests, the meetings? How do you see it playing out? And do you see any change, probably in some years or so? Do you see any change to this judgment?
Well, it is natural that the conviction and sentencing, have, I would say, provoked the kind of reaction that we have seen. I mean, it is natural that it's people, remember, there are people in the Southeast who are very loyal to him. And also there are those who are also not in support of Ipob or ECN and all of that. So yes, yesterday was a great disappointment for those who agree with him, and I can understand their disappointment. So they deserve, also to express that, within the ambit of law. So if there have been protests or there have been reactions, for as long as those remain within the ambit of law, I think we just have to tolerate and understand them. So they have a right to do so. Now, for me, would that escalate the crisis in the Southeast? I don't expect so, because I actually expect that going forward, and I'm happy you said some Igbo leaders are planning to meet the president. You see, now that Kanu has been convicted, and because we cannot also run away from the political reality here. The political reality is that, as I said earlier, this has also degenerated into some ethnic or tribal colorations. So, and therefore, a legal justice may not be enough to redress the crisis. So I foresee a possibility of political solution, maybe in the sense of a pardon, at some point, whether by this president or a subsequent president, I don't know. But I really foresee that because of the political dimension to the whole trial, and when I say political dimension, I do not mean that his prosecution was political. No, I mean the way some people have now tribalized it, the way some people are now ethnicizing it. Whether we like it or not, we have to really take cognizance of that and understand the implication of that on our polity. Some people feel disappointed. They think this is a war against their region. They think this is a war against their people, even though some of us disagree very strongly, because we know that is not the case. His trial is purely a trial against terrorism. But because a country, is built not only on legal justice, but also on social justice, and also the need to make necessary political realignment, to make everybody feel belong, carry everybody along. I am someone who is well disposed to a political solution at some point, and hopefully, Kanu himself would actually have earned that. He will have earned that by disposing, showing remorsefulness. And I think those who are negotiating for him, or those who will be negotiating for him, they will also recognize that, like one of the law lords said, one of the philosophers on jurisprudence of law, Longfulla, he said, "Be you ever so high, the law is above you." What we saw with Kanu yesterday is a testament to the power of the state. Nobody can be big enough and be big enough and be above the state. Nobody. Many people of consequential relevance in Nigeria had been previously convicted or even sent to jail and even did not fall. So if Kanu is even sentenced to death yesterday, I tell you, except for maybe political escalation or whatever, Evo wouldn't have fallen. So the point is that Kanu himself must be spoken to really temper his arrogance, temper his cockiness, temper his, so that in the long run,
Dr. Misbau, permit me to come in here because we're on the home stretch. We have a few minutes to go. Now, let's just look finally in the court of public opinion, because there are many persons who are talking about what has Nnamdi Kanu done that some terrorists, some insurgents that have been forgiven by the day have not done under the policy of de-radicalization. There is that opinion. That's why some persons see it as persecution. And as your parting shot, let's go back to where it started. Is it a crime against the state, to seek for secession in 30 seconds, if you can?
It is not a crime to seek for secession, and my Lord made reference to that. In fact, I say constitutional right. But then, it is not so much about seeking for it. It is now about how you seek for it. People in Nigeria every day advocate for separation. Even the Yoruba people will do it. So the problem with Kanu's approach, or the problem with Kanu was the approach, the violent approach. The evidence are abundant. They are out there. The video, the call to arson, the call to murder, and all of those things. And those things actually took place. So that's the problem. People can agitate, you know, everybody at some point in time, even myself, you know, there were times that everybody got frustrated and you thought maybe the best thing was for each region to go their separate way. So if you do not go beyond merely expressing your opinion, which is constitutional, you will not have committed any crime. And this is why I think people also liking Kanu to Gumi, they are making mistake. You see, Gumi can be very irritating. It can be very disgusting. Yes, and it can be very, very dangerous with his rhetorics. But unfortunately, none of rhetorics of Gumi, as dangerous, as irritating as they are, has amounted to commission of any crime known to Nigerian law. So this is where Gumi is. Knowing a terrorist, or saying you know them, or advocating for settlement with them, or whatever, it's not a breach of any Nigerian law. I'm telling you this with authority.
All right.
But Gumi will be committing crime if he does what Kanu did by actually taking steps to commit terrorism. So this is what people should understand.
All right.
Yes, self-agitation, yes, but violence, no.
All right, thank you so much, Dr. Misbau Lateef, for joining us this morning. Dr. Misbau Lateef is a lawyer and law lecturer, University of Hull, UK. Thank you so much, sir, for joining us today.
Thank you. Good morning. And my pleasure, too. Thank
you. Dear listeners and viewers, it is time to, to go on a break right now. You've heard the last part of the conversation about the recent judgment passed on Nnamdi Kanu yesterday. We're taking this quick break and we'll return for more conversations. Stay with us.